So hello guys, welcome back to another video. So this is chapter 9, and this this lesson that I'm gonna teach you about the offences relating to the business environment and new laws. So this pretty much covers the pretty much the general law of the business environment, and how things have been violated, and what are the certain damages and compensation and offenses that there are if these things are violated. And so this pretty much is a general knowledge based on in business law, in business environment, and it's quite an easy chapter. So let's get into it. So first of all, we got uh, new regulations. So in the field of commerce, because things are what you call you know getting new, and new laws are getting amended uh, every year or so. So we have this Electronic Transaction Act number 19 2006, and amended in 2007 as Act number 25, is to recognize to formation, contract, creation of exchange data, messages, electronic communication in Sri Lanka, and to give effect to the provisions of the United Nations UN Convention of the use of electronic commerce in the international contracts. Yeah, so the objective is to facilitate domestic industrial electronic by commerce, to encourage use of reliable forms of so to facilitate electronic filing, application, petition, plain answer, written submission, or any other document with any code, to facilitate electronic filing forms, to promote public confidence in the authenticity, integrity, and reliability of data, such as messages, electronic documents, and records. It is to implement the convention provisions according to Section 23 Act declared at the ratification of the convention. Yep. And so, what are the legal recognition of electronic communications? So, like Section 3 of the Act. So, data messages, electronic documents, electronic records, things that you has has a data, has a backup, something stored. So, will be under this Act. And it says how the electronic satisfies certain legal documents. Pretty much it's according to the section that they are going through. Please read it out. The sources, which is a scanned image of person's ink signature, hand signature, signature of the bottom of your email, type main, image of a cartoon character. So we got electronic transaction and government institutions. So Section 8 of the Acts permit use of electronic records and electronic signatures in the government, institute, and statutory bodies. Section 9 says that any requirement under a law to publish in the Gazette is fulfilled by publishing in an electronic form of the Gazette, and the government institution body may accept or issue documents in the form of electronic records subject to monitor transaction, the electronic forms. So get electronic contracts that it bind. Electronic communications. So this refers to the communication center to automate a system program of the originator by such communication to receive call as an addressee. So originator is refers to the person who sends or generates the communication, also include any person who generates such communication on behalf of another. So electronic communication, so things that you send as a message, sends out a video clip, voice recording. So in this act, it has been mentioned. So who's the originator? Means the sender, the person who starts the communication with, so addressee is referring to the person originating the communication. So the person who receives the message is known as the addressee. Dispatch of an electronic communication. Section 14 says that when such communication enters event and information which is an outside control of a negotiator, or such communication has no left information system which is under the control of the originator, when such communication is received by the addressee. Yeah, and the section 13 also says that something similar to that. Time of receipt of an electronic communication. So section 14 says that the originator must have decided that otherwise receipt of the electronic communication shall be determined as follows. If an information system is previously designated by the addressee to receive such communication, time of receipt occurs at the time when the communication becomes capable of being retrieved by the addressee of an information of the addressee which is not the system designated by the addressees such as receive the communication of time being received occurs. So quite general knowledge. And the certification of authority. Section 18 of the Act provides the clear certification of authority. This authority entrusted implementation of the Provisions Act. It is also employed under authorized service certification service providers. Powers of certification authority. Section 19 says that to identify the criteria of granting license or authorization, to hear appeals and specify the procedure to be followed, to specify the procedure for the hearing of appeals in the event of a refusal, to issue licenses of any other form of authorization, certification service providers, to require certifications, service provider to maintain the records, to call for information of certification providers, to issue direction of the CSP, certification service providers. So who are the certification service providers? A certification means that which is somebody provided to the sender's recipient has been information in electronic form, those who storing such information to ensure that the confidentially such information is secured. These services will be make use of cryptographic techniques for this purpose. Yes, exactly. So things that you send it through mail and you got it back noted with thanks, things also simple as those things also will be under this covered under this act too. So also send an email receipt said you have been received. So things that you purchased, such as in Daras and AliExpress, things like that, they will send you a receipt. Thank you for doing business with that. Here's the receipt that you have taken. Maybe it can be mentioning the prices, mentioning the business name and the products, the number of products that you ordered. Yeah, so that's it. And the accreditation of certification of service providers. Section 2 also mentioned, 20 also mentioned that. So applicability of rules of governing evidence. Section 21 subsection 2, anywhere information contained data, message, electronic documents, electronic and other communication touching on any fact is issue or relevant fact, compiled, received or obtained during the course of any business, profession or other regularly conduct activity, shall be admissibly in any proceedings. So who is dead, unfit to alienate, who is outside Sri Lanka and where reasonably as steps have been taken to find him cannot be found, who does not wish to give oral evidence through fear, who is prevented of giving evidences such as relating to uh, such information shall available be admissible. Section 21 subsection 2 uh, says court shall, unless contrary is provided, presume the truth of such information contained in any such data, message, electronic document, electronic record or other communication, and where such was made by a person, such information when made by the person who is supported purported to made it, and shall presume the genuineness of electronic signature. So section 22 says that the provisions in evidence special provision act shall not apply to data, message, electronic documents, such communication with therefore the act is this act is supreme. This act is brought to address certain practical difficulties that arose when following the requirements under the 1995 Act. Items not covered under the Act, such as creation of implement of wills, and license of communication, telecommunication act, bills exchange, under the BEO, transaction regulatory exchanges, transfer security rights in sale, the power of attorneys, trust ordinances, contracts of sales, and any other documents regulated by the ministries. Yeah, so Computer Crime Act. Main objective to identify Computer Crime Act to provide procedure investigate such as crime to prevent such crimes. So, what is a Computer Crime Act? So, according to the Part 1, Section 3 says that any act secure unauthorized access to a computer or any information held in the computer to act to secure unauthorized access to a computer or to any information held in a computer with the intention of committing an offense. Uh, Unlawfully causing computer perform a function which will result in damage or modification to the system or the computer, uh, endangering national security or national economy by making a computer perform certain functions, um, buying, receiving, retaining, selling, or in any manner with any information obtained from a computer or storage medium by another person unlawfully, illegal interception of data to or from a computer. So those things are covered under the Computer Crimes Act. Um, so investigation of computer crimes, or how do they investigate? To enter to any premise along with the police officer who is not below the rank of sub-inspector, to access any information system, computer system, program data, information held in such computers, to receive any person disclosing traffic data, verbally question a person. To do such things may be reasonably required purpose for purpose of this act. Section 18(1), the act authorizes expert or police officer under the authority of warrant issued by the magistrate to obtain any information to intercept any wire or electronic communication, but even without the warrant, an expert or police officer is authorized to perform in any above mentioned tasks under the following circumstances as per section 18(2). So, yep, these things is quite so it says under section 20, whenever possible, every police officer in expect in investigation do not hamper use of any electronic, any computer or no such under the cause of a legitimate business. A police officer has a power to arrest, search, seize or in any information accessible within the premises being investigated in the manner provided by the law. And section 20 says that the compulsory of a person and all person engaged under this act maintain strict confidentiality with regard to such information coming their knowledge, which is covered is under section 24. So we got Consumer Affairs Authority Act number 9. So in this Consumer Authority Affairs is to promotion of the competition of protection of consumers, regulation of internal trades, establishment of Consumer Affairs Council, repeal of Consumer Protection Act number 9, fair trading, all matters connected to there with the incidental thereto. So we got Consumer Affairs Authority Act established the Consumer Affairs Authority. Objects of the Consumer Affairs Authority is Section 7 Act gives objects of the Consumer Affairs to protect consumers against the marketing of goods or the provision of services which are harmful to life and property of consumers, to protect consumers against unfair trade practices and guarantee of consumers, to ensure whatever wherever the possible consumers have sufficient access to goods, to seek damages of unfair trade practices, restrictive trade practices, and other form of manipulation of consumer by trades. So, constitution of the authority, section 3(1) says that the authority shall consist of chairman, not less than 10 other members shall be appointed by the minister from among the who possess the recognized qualification and had wide experience and distinguishing themselves in the field of law, commerce, economics, administration, accounting, and science or health. So, function of the consumer affairs to control and eliminate of the following: restricted trade, agreements among enterprises, uh, agreements among enterprises with regards of prices, the abuse of controlling position regarding domestic trade, economic development within the market, and restraint of competition adversely affecting local or international state of economic development, to investigate, inquiry, competitive practices and abuse of a dominant position. Uh, uh, yeah, so anti-competitive practice is a practice which a person, of course, a business pursue conduct likely to affect preventing competition in relation to any other goods or services in Sri Lanka. To maintain and provide effective competition between persons supplying goods and services, to promote and protection of the rights, interest of consumers, purchasers, and users other goods, relation to the price, availability, and quality in such goods and services, and the variety supplied. So yeah, quality, potency, and purity. So these things are pretty much covered up until to section 28. So what are the things that the Consumer Affairs Authority does? The power of authority regulation internal trade, so which says as price marketing labeling, authority maintain a written agreement of the manufacturer or trader provided, determining standards of the specification. Specific goods must be um, under the ministry's gazette. So what are the goods and specified services that I mentioned in previous lectures? So these things, main offences under this act is selling or offering to sell goods above the price market on the goods. So uh, selling it overpriced, refuses to sell goods by trader when such goods have been obtained by him for the purpose of selling in Sri Lanka, which are in custody and control. So if there are goods in a supermarket or places, or like a retail shop, if the owner is refusing to sell the goods, such as, especially during pandemic and curfew times, there are if there are goods and shops, goods in a shop, and the refugees refusing to sell, because they might be using for their own purposes, you can complain it to the nearest police station and says that, since this is a pretty much a public place, this is a public shop, everyone comes and buy it. The refugee is refusing to sell it during pretty much during this curfew time, because they are using for their own benefits. So that's how it is. So the police officers can come and seize the goods, and will take taken from them. So denial of possession any traded goods, subject to any conditions such as any such possession of a trader, purpose of the trade, hoarding of goods, any other person, to increase price in goods and services declared in essential to life, manufacturer, trader prior to the approval of the authority. So the authority, the ministry must approve the increase of the sale of the prices and the goods, because they cannot, because there's a price limit, the price range has been set by the ministry according to the quality and standard, according to the market. So you cannot sell above or far more lower, because it will be an unfair competition in the business trade. So obligation of traders under the act. So the exhibit conspicuously in this place of business price list containing the maximum retail or the wholesale price of good available in the sales of places. So to issue a receipt of any goods sold by him, goes to register himself, to keep a notice of a prominent place of the business, to mislead, deceive any customer or trader, to make any false representations. So that's what the things are. These are pretty much general, and pretty much a general overview of the acts that we are talking about relating to businesses. And let's get it on the Intellectual Property Act. So this is one of the most important acts in Sri Lanka. Many intellectual properties are violating in Sri Lanka, even though we have strict regulations, but there's no liability, there's no what I call imposing imposition, so things like that. Uh, Imposing of the law. So the police mainly, mostly the authorities are unaware of this act, but this is also an important among lawyers, among the business personnel, when they are registering their logos. They are There's some sort of court that they present themselves. Uh, they pay a publication fee into the intellectual property office. So that's how it is. It's quite important, but normally these things are violated, such as movies, songs, which they are being used and misused by different person and not crediting the original owner. So, yeah, let's get into it. So, this provide an efficient procedure of registration, control, and administration of the law to provide District General Intellectual Property of Sri Lanka. And the meaning of intellectual property says uh, rights including intellectual activity, industrial, scientific, literary, or artistic field. So these are the areas that they specified on. So in a business logo, business manufacturing things, scientific research, what they have found, literature, the books, things that they wrote, or the poems, things like that. Artistic works, it can be from arts that you draw, the potteries, things like that, and to up until to the music, music works. So anything related to those things under this under these categories will be protected under intellectual property. So, but first of all, you have to register of whatever the things or the creation of the invention that you have. Make sure you register it prior to the other parties, because the other parties as registered before you, they will have the ownership. So unfortunately, either but when that happens, either you have to buy from them if they're willing to sell it to you, or you have to change your the background, or maybe the logo, the codes, or anything, whatever the relating to the field. Maybe find a new one. So rights of ownership, which is intangible assets, artistic creation, expression of technical idea, conferred by the sovereign state on an individual person, corporation, and excluded others, making, selling, distributing, importing, copyright, copying, otherwise exploiting the asset without the permission of the owner. Copyrights related to the rights, industrial properties, invention, industrial designs, like I said before, geographical indication, trademarks, and trade secrets. So, uh, intellectual property recognized under this act is copyright, industrial design, patents, marks and trademarks, trade names, layout and designs, geographical indications, things like that. So copyright is normally things that you copy from others and you make it by yourself. So that's also a copywriting. So industrial designs, uh, you can see such as designs of different what you say creations, such as what you say different types of alcohol bottles. They normally secure with different types of laptops, electronics, furnitures, housing schemes. So these things they are pretty much protected under industrial designs. So patents, so things such as any invention that you have found out, or that you are planning to see. So it can be industrial logo, can be anything. So from scientific research or things that you invented already, has to be registered under patent. So you have to take a patent license. It's quite expensive, but when you start selling it, if by your own, you will earn a huge amount of money. Marks and trademarks, so a logo of a company, classic example, Apple logo, so these things are copyrighted under these things. Logo of McDonald's, KFC, these things are copyrighted. Nobody can use it, the logo, under a different name, changing some things, because eventually those companies will sue you related to that. And trade names, Apple, Samsung, those things. uh, Trade names are also secured. Layout and designs, like I said before, um, geographical indications, you know because Sauvignon Blanc from France, Champagne, things like that. Scotch whiskey. Scotch whiskey has to be used because if that whiskey brand comes from Scotland itself, nobody can use American whiskey brand cannot use as Scotch whiskey. They have to use some other name relating to them. So we guess Tennessee Jack Daniels. So they have taken up their Tennessee, which is the state that pretty much the whiskey brand was founded upon. So that's a geographical indications. Yeah. So the main case in Sri Lanka is Subi versus Subi. It says that provisions Act of the 2003 is similar to indication IP laws jurisdiction foreign cases like India, UK, and USA restored where to applicable. So let's get into deep. So what are the copyrights? It's law relating to copyrights such as into the intellectual creation will be treated as protected. So if anyone copies such protected work without permission, demand will punishable under this effect. So what are these copyrights? Protected works, artistic and literary, artistic and scientific works. If you are copied from others and you take it as up your name that you things that you have already invented, this is my idea, things on the original worker who actually or registered their work can sue you under copyright acts, such as I wrote the book of a simple one, Maname, the Maname drama. It was written by Mr. Idirivira Sarachandra. So these things has been used for the public use, for student use as a free. It has been given. So if I use a if I write the book, Maname, and putting my name and sold it in bookshelves, I'll get sued under Mrs. Sarachandra due to the copyrights because even though these things are public use, it has been so it's still protected under the copyright law, so things like that. It's easy. So these are the things: audiovisual, architectural work, dramatic science, speeches, books, pamphlet, photographics works, app arts, illustration, maps, translations, original collection, databases. Yeah, it's all under copyrights. So duration of the copyright, things you have to mention is general rule is that copyright is registered under protected during the entire lifetime of the author. Exactly. So what happens if the author died? Exactly. The day of author dies, um, period of 70 years will be protected. So the 70 years of their work will be protected on the day after the author dies. So let's say author dies in 2001. From that year or that specific dates, it must go for 70 years from that date, and after that it will be free to use to the public. Anyone can be used, anyone can be have their own record, their own thing, their own versions, and be put into market. But it has to go 70 years after the death of the original author. So let's say William Shakespeare, his drama, his artistic work, such as Beethoven, the symphonies, these things, because it has been way more 70 years of the times. Things can be used as the public use. Any orchestral symphony can use Beethoven's music. Any drama, any author can use William Shakespeare's uh, own books, and they can sell it, any publication, any company, and they can sell it on freely because it has been a very long time since after his death. That's how it is. And so section 13 gives also exceptional to this general rule. So these are the exceptions. Uh, so after 70 years, uh, things like that. So after the death of 70 years also, in case of collective art workers, so audiovisual art protection will be 70 years from the date of its failing to publication within 70 years from the making the work. So the says work published anonymously under the pseudonym protection for 70 years. The work was first published by the author's identity reveals the expiration of the 70 years, which will be 1 and 2 is applicable, will apply. In the case of work of applied art, the protection will be 25 years from the date of making the work. Each time the period is mentioned above shall run to the end of the particular calendar year without the expertise. So artworks, it will be 25 years, such as the picture, the art of Mona Lisa. It has been several centuries. So any artistic person can draw a Mona Lisa uh, because it has been a very long time. So the duration is pretty much 25 years. So they can register it for every pretty much 10 years. They have to keep registering it. So mainly things like that. So uh, so normally, speaking of things, after the author's death, the pretty much the family will own the copyrights of the particular what you call the artistic work of the author. And if their children or someone from their legacy will be continuing their work, they can register it under their name and they can keep moving on. But even though the author dies after 70 years later, they will because if they are taken under their name and they kept registering under their names, but the original under the original author, that has to be done by the family member, or you have to buy from the author that the work that he or she has done and can be registered under your name as well. So let's go on to industrial design. It's covered the section 30. So the lines of colors, three-dimensional forms capable of serving as a pattern, product or industry or handicraft has to be registered obviously under the provision of the act, or registered will be designed by register of industrial design under section 42. So registration is valid pretty much of 5 years and has to be removed 2 or more consecutive 5 years of the opinion. Exactly, for 5 years the industrial design has to be right. So these things takes two forms: economic and moral rights. So what are the economic and moral rights? Economic rights, obviously, right to sell, right to reproduce, distribute, communicate, public, and translate, translocate anything for your own economic benefits. What are the moral rights? So the right to claim the authorship and the right to oppose distortion or mutilation of the works. Yeah. So like I said before, a song, it has been not sung by the original order, has been, we say, remixed by another person, remixed or maybe used as their own music, and selling it to the public will be known as under the laws of moral rights has been or distorted and mutilated my song, my music work. So therefore I will go to courts regarding that. Either I can come is pretty much claiming compensation or putting an injunction to stop to work. It can be go on as imprisonment too if they wish to. So economic rights can be covered under section 9, reproduction, translation, adaptation, things like that. uh, they can display their goods, their copy, they can broadcast, they can perform in public, they can do anything that they want according to their works. So moral rights to indicate prominently copies of the connection with any public use of work. The right to use pseudonym indicates a copy with the public use of work to object any distortion, mutilation, and other motivation, derogatory work. So these things pretty much under covered moral right. So infringement, section 178 says that willfully infringes in any rights to protected under part 2 shall be guilty of an offence, shall be liable of conviction after trial before magistrate to a fine not exceeding 500,000, yeah, fine of 500,000 or to imprisonment for term not exceeding 6 months or both such fine and be such imprisonment in the case of second or subsequent conviction such fine or term of imprisonment or both such fine and imprisonment may be doubled. Exactly. So subsection 4 says that magistrate may, whether the alleged offender is convicted or not, the order shall be copies of the work and be implemented use of the infringement or placed in the possession of the alleged offender which appear to him to be infringing copies or plates implements used for the purpose of making infringing copies shall be destroyed, delivered upon the owner of the rights dealt within such as the magistrate may think it fits. So if you has done copyright violation, the magistrate can issue the judge can issue an order to seize all your uh, uh, derogatory copyright works that has been mutilated work of the original author. They can seize from shop, they can seize from your house, and they have once they seized all of your work, they had the right to destroy your work because it has been distorted and mutilated against the original author. The original author and the magistrate can give back the rights things to continue their economic monopoly in their work. So you will be guilty of an offense not exceeding fine of 500,000 or a 6 month of imprisonment, or it can be both, it can be the other way around, but it depends on the level. So sometimes if the author thinks that the compensation, the punishment that is not getting right, they can appeal it to another high court, to a much more higher court. Supreme can be go up to the Supreme Court. So they will be liable. They can be imprisonment for more than 10 years. So patents. So invention of the act refers to an idea um, for the inventor permits to practice a solution specific problem in the field of technology. Yeah, so the patent is, as per dictionary, it says license to conferring exclusive rights for an inventor to use to make a sell of invention of particular number of years. Yes, like I said before, is a license that you get for your invention to protect the rights of your invention and to prohibit to sell or to manufacture of other companies. So without permission of yours, either they can hire you as a main body. So such as Mark Zuckerberg of Facebook, he founded Facebook, and now he's the pretty much the CEO, whatever the chairman is. But he no longer operates a company, he's just the face of the company, but another company is the one who like operates Facebook, and he'll be getting some sort of annual interest, depends on the profit that the Facebook makes. So that's how it is. uh, so yeah, so the this register so pretty much valid is for 20 years of a patent. After that they have to keep renewing it. uh, So the says that to exploit the patent invention to assign and transmit patents to conclude version of the contract. So what can be permitted? Patent, you know. So novelty, non-obviousness, inventive steps, and industrial application, and conditions to be met. Invention not only the public prior to claim of the inventor, and inventive steps are invention would not be obvious to a person with ordinary skills in the art. Invention can be made a useful practical activity distinct of purely intellectual one. Yeah, that's how it is. Patents, very simple, very easy, really straightforward. And marks and trademarks, yes, it can be a distinctive word, logo, domain name, graphic symbol, a slogan that the company promotes them for you to uh, what you call to protect their rights, to market them, things like that, such as what you called I to be honest, I can't remember what are the marks and slogans are. It doesn't come into my mind. We say Cargill's Food City, Gidare Anagamang, those things are pretty much under copyrighted, things like that. Slogan, they has to be copyrighted, but the other company cannot be used Gedare Anagamang because it will be pretty much undervalued. If the Cargills has copyrighted that slogan, uh, but they can argue in the courts, such as this is a very common thing, it's a very common word. Anyone in the street will be used Agedare Anagamang, things like that. But blah blah blah. But it depends on the level of law that's been inflicted by the both parties. Uh, yeah, so any visible sign, like I said before, Apple logo is a classic example. McDonald's, KFC, these are globally recognized brand. Also Microsoft, Windows, you know, those things, uh, um, which are like global brands, which everyone knows. So these things are covered under trademarks. So So these are the things: type of trademarks, words, styles, logos, slogans, product shapes, product packaging, combination of types of marks. It can be one, not one logo, maybe different types of logos, different types of marks. Every logo is pretty much covered, especially logos of vehicles are also patent. So these things, collective marks also, registration of the mark according to sections 1102 is that the safe has to be interest of the owners are unregistered mark to a reasonable extent to providing the protection of well-known marks with Sri Lanka by introducing the protection against act of unfair. 102 says that first to fulfill the condition of valid application, first to validly claim that the earliest prior to this application, upon the fulfillment of criteria by the laid down the act, the Director General will issue the applicant with a certificate of registration confirming the registration of the mark. So all the registered marks will be recorded by the registration of marks, section 113, which public document can be inspected by any person. Mm, Inadmissible marks. So marks cannot be registered under call admissible marks under things. So admissible marks, swear marks, we say such as middle finger. You cannot trademark a middle finger. These things, or some sort of such as admissible marks, such as the Nazi symbol. You cannot admissible that because it's violent to hatred, promoting for hatred. Those things, nude pictures, whatever the things cannot be registered under the act. It depends. So once you bring a logo, the intellectual property office will IPO, will look into that. They will examine it. They will research through it, and they will come and design it. So this is an admissible mark, inadmissible mark, so you cannot register it. It's against the law. Please come back with another logo design for your company. Yeah, so duration 10 years, easy. You have to renew for every 10 years. uh, so rights of registration owner, exclusive use of the mark. You can use anywhere for your products, brands, companies, offices that you use. To assign or transmit registration of the mark, to conclude license of the contract. So any contract by the which a registered owner of the mark grants another person to license to use the mark for all part of the goods and services in respect of which mark is registered. So contractors and subcontractors also can use the marks as long as the contract, until the contract expired with the company. So yeah, That's how it is. But sometimes the uh, the, the owner, the person who provides the contracts, the owner of the company can refuse to do so. Well, no, you're not. You are a subcontractor. You are not a part of the company. You are a third party. So we cannot allow you to give our any types of trademarks for you to display in your company. You can take trade names. Simple and easy. According to Section 101, says that in Section 103, prohibited trade names are there for public morality or the offender religious or racial feelings of any community that mislead to the public. You know, uh, these things uh, which is inflicting morality and in sort of some sort of an offense to the public will be not name will be not registered under trade names, such as swear words, uh, anti-religious words, anti-racial words, things like that. Those things are prohibited under section 143. And also it will be researched by the committee of the IPO, and they are the one who will say no, yes or no. Yeah, and layout design, integrated circuits. So product is a final form of an intermediate form, which is elements of such as active element or some or all of interconnection integral formed, which is one piece of a material uh, intended to perform an electronic function. Layout design is defined an three-dimensional disposition of the elements, which is active elements, some sort of interconnection, integrated circuits such as three-dimensional prepared for integrated circuit intent for the manufacturer. So these things are pretty much technical, based on technological things. Register of layout design under 147 has to be says original. The word original is important in intellectual property. Original means the owner, who the one who designed it, the person, or you have given someone for a contractor to design the logo or anything. So the original rights will be under you. So 161 says that once register layout design will be recorded in the register of layout designs. Public document can be inspected by any person. Exactly. So these things are under for the any person, public person uh, can be inspected whether what sort of logos that they have designed, but they cannot use this logo which has been already registered. Duration of the registration: 10 years of the calendar's time of the date that they have what you called registered their industrial layout. Let's go to geographical indication, section 101 and 161, and geographical indication goods original territory of the country, region of the local authority, and territory where in a given quality of repetition on other characteristics of goods are essential are determined by its geographical origin. Protection according to geographical origin: any Sikh person protection are this act of the following to prevent the use of means such as goods in question originates in geographical area other than true place of origin in the manner misleads the public geographical origin of goods. To prevent any use of geographical indication will be considered an act of unfair competition. Exactly like I said before, Tennessee whiskey, Jack Daniels, because they have registered, it's in the Tennessee state, I believe. From there, if they have registered it, no other any company in this Tennessee cannot use unless if they are from Tennessee. If you are from New York or any other state, they use the word Tennessee whiskey, it'll be against under the law. If the Jack Daniel company has registered that under it, so the geographical location is quite important. Uh, Pretty much. What I called is important. It's crucial. There was a court cases for uh, for champagnes because the word champagne is actually it's actually a town in France. It has the champagne, the drink has originated from. But there are other places in the country they make champagnes, and there was so a court cases into the international court stating that Champagne is a geographical location. It's located in France. It has been originated there. So therefore, any other cannot use the word champagne because it's in France itself, and kept going so on. But it's the industrial court decided it's too broad to argue because these things has already been registered under the international law and their own respective countries. So therefore it's null and void. They cannot exercise that sort of a far larger into the jurisdiction. So it became uh, it became redundant, it became null and void, and so on. And in recently, India and Pakistan is fighting over the name of basmati rice, due to the location was, because basmati is like some sort of town or village in India. So the basmati rice originated from India itself, but the Pakistan is pretty much a main export of basmati rice of different countries. But in Sri Lanka also we use Pakistan basmati rices too. Uh, so therefore India and Pakistan have some sort of a legal dispute regarding that, of using as the word basmati of rice for the Pakistan rice distributors as well, because basmati rice is originated from India and it's a town located in India too. So these things are quite important regarding this. So these are the protection on this. To prevent use of means presentation of goods such as the place of goods and origin, true place of the origin, the manner of mislead to the public, direct indication in the manner will constitute an act of unfair competition. So yeah, that is pretty much the end of the Intellectual Property Act. So, and we'll get on to the right to information. So this is a very recent one, has been conducted by the previous government. Right to information. So it is the right to access information held by public authority. This may be complete or partial release of information held by the state. In many countries, this freedom is supported and constitutional right. This is also known as freedom of information. Open record sunshine laws, typically bound by the duty to publish, promote openness. Thus, therefore, is often described as law steps keep citizens in the know about their government. So, uh, so there's an RTI commission just maintained, things like that. So many right to information act was brought upon, is actually hailed and appreciated by the Western countries to give people a relief that if there's some sort of a missing person, during the war times, the family of the missing person can has a right to know the information of what happened to the governments, these things like that. And if this census act has been replaced, mostly police brutality and the forces brutality has been severely decreased. But if you have some sort of a misplace, things had happened, you can sue upon any, not just forces, any ministry, anything, such as under right to information act, because if things are in publics, there are in exceptional cases such as intelligences, protection rights, state secrets, things like that, it will be pretty much protected. But mainly things, especially a missing person, you can actually sue them under right to information. What happened to my son during the custody, what happened, things I need explanation, and things like that. If the authorities are refusing to do so, they can go to courts. So the applicability of the CARE Act. So citizens shall have right to access information on person of custody or control of the public authority. Yes, like I mentioned before, what is a public authority? Minister of the government, Constitution Act, or the Companies Act, the government departments, public corporation, things like that. Denial of access information will be according in Section 5. It will be inform will be real personal information disclosure which has no relation to a public activity or interest, which have caused unwarranted invasion privacy individual, and is a large public interest that justify the closure of such information or the person concerned has consented written such disclosure. So would undermine the defense of security, territorial integrity of national security. So according to the public thing, so disclosure of such information would cause serious prejudice to the economy of Sri Lanka, and president this will not continue. So we normally talk about the commercial side of the right to information. So a regular banking of credit, taxation, stability and control and adjustment. So a state or any company can ask a company of right to information, show your taxes, show your banking credits, show your whether you are stable, so your adjustment of the price, things like that. If they are refusing to do so, they can sue the particular company. So yeah, also it includes the Intellectual Property Act as well, to show the right to information, to have the right to information, to see uh, the publicity. So it keeps going. So this is a highly controversial, a very what you call a large act that has been published by the previous government. So it's very important. It's very nice things that they have done. So police obtaining information. So any citizen who desires obtaining information under this act shall be make a request in writing appropriate information officer specifying the particulars of the information requested, where citizen is to make a public authority has to be made. Yes, so they have to have like some sort of a written um, letter has to be performed and make some sort of stamp payments, and the citizen can access any type of information. So these things, um, appeal against rejection. Any citizen who been aggrieved by the decision is rejected by request under any following. So under section 31, a citizen who is aggrieved the results of refusal request made of information, refusing access to the information grounds such as information exempted, non-compliance with the times of frame specified by the Act, charging an excessive fees, refusal of information officer of the form of requested, citizen requesting before an appeal designated officer, any citizen, section 31(1) maybe appeal of commission, things like that. Any citizen aggrieved decision on 31(1) may appeal in commission. If the citizen is further aggrieved by the decision of the commission, may appeal such against that decision in the court of appeal with 1 month of the date which was decision committed by the citizens public authority. So yes, interesting these things. And so a crucial act has been passed. So citizen who request information has a right to inspect relevant documents record, can take notes, certified copies, documents and records, take certified samples of materials, obtain information, diskettes, floppies, tapes, video cassettes, or any other electronic modes or through printouts where such information is stored in the computer of any editor. So the person who requests, then they can ask copies, pay some sort of a fee, ask copies of printouts, floppies, tapes, video cassettes, anything of the work, and they can go so, but they cannot publish under their name. They can go it because they can use for their own benefit, their what you call their own information records, to know it better. That's it, and so on. Electronic modes, any sort of you can any documents you can ask for printout, but you're not allowed to take pictures from your phone. It pretty much prohibited because of that. Yep. And yes, and that's all this for this lesson. So yeah, the offenses related business environment and new laws, the chapter 9 has been concluded, and then I will see you on the chapter 10.